SJC-11640, Town of Athol v. Professional Firefighters of Athol, Local 1751, I.A.F.F.
Cities that have comparable programs.
Are you alone today?
No, I see opposing counsel right over there, so.
So intrigued with the last argument.
He's still pondering it, yes.
All right, now you have a brother. So now you may proceed.
May it please the court, my name is Ian Russell, and I represent the Permanent Athol Firefighters Association, Local 1751, the union that represents the town of Athol's firefighters. What is at issue in this case is whether the Superior Court and the Appeals Court erred in determining that a portion of a labor arbitration award must be vacated on the basis that it conflicts with a particular statute, in this case, Chapter 32B, Section 7A, when the factual record, which was established at arbitration, does not establish that this statute was applicable.
Well, let me ask it the other way. Does it the issue is whether 7A doesn't apply to
Yes, our argument is that 7A does not apply to non-indemnity plans,
Right.
including an HMO plan or the plans that are at issue in this case.
And what we're talking about is only HMO plans?
So at the arbitration, there was no finding of fact as to what the plans were. There was...
But there's two
Well,
names.
there was a finding that there were two, so let me rephrase that. There was a finding that there were two plans, one of which was HMO Blue, which is clearly an HMO plan, and
And it has no indemnity provisions, or we don't know that?
it is a straight
HMO.
HMO.
Okay.
The plan summary documents are in the record. They were a part of the record at the appeals court. The other plan is Blue Choice. There was no argument at arbitration as to whether or not Blue Choice was an HMO or an indemnity plan, because at the arbitration, the town never raised the issue of the application of 7A. In fact, throughout these entire proceedings, the town has taken the position that under Chapter 32B as a whole, it has no obligation to engage in bargaining with the union about the decision to increase co-payments or the decision to change contribution levels. So there was no argument related to 7A or 16 or Section 16 at arbitration because the town was not raising this argument at arbitration. And I would say that the town has continued to not raise that argument, and that the argument that the Superior Court attributed to it, that the uniform contributions language in 7A is what required partial vacating of the award, was not the argument that the town was making. If you look at the brief that the town filed with the appeals court, in fact, the town stated that the difference between Section 7A and Section 16 is a distinction without a difference, and that this was not the historical issue that was presented to the arbitrator or to the Superior Court. And even today, in the briefing that was presented to this court, the town continues to argue that it had no obligation to engage in decisional bargaining with the union because it is excused from this obligation under Chapter 32B as a whole. So the position of the union is that the dispositive issue in this case is that there was no finding by the arbitrator that either of these plans were indemnity plans. We believe they are both HMOs, and there clearly can't be an argument that the HMO Blue plan was not an HMO. So there was no finding that either of these were indemnity plans, yet the Superior Court determined that it was obligated to vacate the remedy of a return to the status quo and making whole bargaining unit members who were required to pay higher co-pays. So under Uretsky, it is clear, Uretsky v. City of Attleboro, it is clear that there is a big difference between 7A and 16, and that it is only through 16, Section 16 of Chapter 32B, that towns can offer HMO plans, and there is no uniformity of contributions language in Section 16. In fact, Uretsky discusses the fact that there will be different levels of contribution, and that without collective bargaining, union members would only pay 10%, and it's only through collective bargaining that they would pay higher than that. Whereas Uretsky states that non-unionized employees, their contribution rates will be determined by the political process. So there is no uniformity issue if the statute being applied is Section 16, and it's the position of the union that that it was the appropriate statute to be applied, and that 7A could not be applied. We understand that the appeals court acknowledged that Section 16 is what applies to HMOs, and seemingly acknowledged that there is no contribution, uniformity of contributions language in Section 16, and yet it still affirmed the decision of the Superior Court. And the basis for that was the finding by the appeals court that the union had not sufficiently argued that 7A did not apply. Now,
Is it your position that actually, at this point, it was the town that needed to argue that it didn't?
yes. So point one is that in the briefing to the Superior Court, the union did state that Section 7A only applies to indemnity plans, and these are not indemnity plans. But there's also the fact that the union prevailed at arbitration, and it was the town that sought to vacate the award, and it was the town that had the burden to prove that the remedy or the award itself violated the law. The position that it took was that, the Superior Court took, was that compliance with the award would violate the law. It was the town's burden to prove that this were the case, and the town never made any attempt to create a record to show that that's the case. And that is because time and time again, through arbitration, Superior Court, Appeals Court, and now here, the town has taken the position that it is Chapter 32B as a whole that excuses it from its obligation to bargain. In fact, if you go through the briefing that has been filed by the town, you'll see that it is not relying on 7A today. It was not relying on 7A in front of the appeals court. If you look at the complaint that it filed when it sought to vacate the award, it doesn't make any reference to Section 7A. In fact, I believe it refers to Section 3 of Chapter 32B. If you look at the statement of the issues that the town presented to this court, it states that the issue relates to Chapter 32B as a whole, and I believe it cites to Sections 1, 2, and 3, but makes no reference to Section 7A. In fact, at a point in its brief, the town includes a large quote from Section 16 in support of its argument that it had no obligation to engage in decisional bargaining with the union. So I would say that the town, we don't think they were ever raising this argument, the argument that it was attributed to it by the Superior Court, but if they had ever raised it, they've long abandoned that argument. Briefly, I would add that even if the union had not made a statement before the Superior Court that Section 7A did not apply, which it did, and even if the town had taken the position that Section 7A was the crux of the matter and was what made the remedy violate the law, this court could still address the issue because it is clear on the facts of this case, as were found by the arbitrator, that these were not indemnity plans. There's no finding that there's an indemnity plan, so the court could still address this question since it is a pure question of law as to what statute applies to non-indemnity plans. I want to briefly, before my time is up, since we did file a motion to strike, just address that. And the basis of that is purely that the town did not file a cross appeal after the Superior Court's decision was issued. And yet the town's brief is basically, its entire argument is that it was not required to engage in decisional bargaining. The arbitrator found that they were required to engage in bargaining. The Superior Court confirmed that and ordered them to engage in bargaining, even if it vacated other portions of the remedy. So the town cannot come here today and ask this court to say that it was only obligated to engage in impact bargaining, or that the finding of fact made by the arbitrator about the type of bargaining that was or was not engaged in is incorrect.
Thank you. Thank you.
Albert R. Mason for the city of Athol, or town of Athol, I'm sorry. In regards to the statements that were just made, town of Athol is talking about 32B as a whole, has talked about 32B as a whole from the beginning.
But you didn't
Paragraph
appeal.
7, page 7 on the appendix will show that the town pointed out that since 1997, the leading case authority for determining what matters are subject to collective bargaining or arbitration has been the City of Lynn versus Labor Relations Commission. And in that case, they point out that matters that are not subject to either collective bargaining or to arbitration are matters that are within a governmental employee is acting under the terms and provisions of a comprehensive local option special law like Chapter 32B. And all of the case law since the City of Lynn concerning labor relations spells out to a T that if, as a matter of fact, you have a situation involving a local option law that's not listed in Section 7 of 150E, because collective bargaining in the public sector is
Mason,
not like
what are we supposed to do about the fact that you didn't appeal?
I didn't have to. I put it in it's in the complaint, and it's in the argument. It's been in the argument from day one. If you reading the argument, it's all about local option, not listed in Section 7 of 150E, and specific purpose law. That was what it was all about from the beginning. And it's in the complaint, and it's in the argument by the town from the beginning, saying that, as a matter of fact, this was not a matter that belonged in arbitration. It's not a matter that belongs in collective bargaining. In fact, a big part of the entire problem with this matter, as was requested to strike the town's conclusion in its complaint that, as a matter of fact, this matter should be addressed, goes to the words bargaining and goes to the words contribution. And what the union has been saying is bargaining, bargaining. You know, they're not talking. That's what you need to address. That's what the Court of Appeals didn't address. That's what the Superior Court didn't address. Bargaining in public sector is not bargaining. It's decision and successor bargaining, and it's impact bargaining.
Why didn't you appeal from the Superior Court decision then?
Pardon?
Why did you not appeal from the Superior Court decision?
Because we prevailed. We prevailed under Section 7A, uniformity, which is whether we prevailed under 7A, whether we prevailed under 3, whether we argued 32B as a whole. Every provision of 32B, whether it talks about the indemnity provision or whether it talks about the HMO provision, says that it's the appropriate public authority that determines the plan design, co-pays and deductibles, not premium deduction, not premium contribution. Okay? And that's what's happening in this case. That's what's happened in this case from the beginning. Tammy Briney, the arbitrator, is an ex-Department of Labor Relations hearing officer. Their business as an administrative law agency is just like the Workers' Comp Board. Every administrative law agency is put into existence to promote the purpose of their existence. And DLR is in business to promote collective bargaining. So she clearly said, let's bargain. Let's bargain. But that's not what your court case law. And this court has said ever since Lynn versus Labor Relations. Ever since Lynn versus Labor Relations, this court and every court that has addressed local option, comprehensive laws addressing specific matters have said that, as a matter of fact, collective bargaining is not like private sector. It's not open-ended. It's limited in the public sector. It's limited to the categories that are spelled out in Section 7 of 150E. Those are the mandatory subjects. Those are the ones that are subject. And it's also limited from the point of view, your most recent case with the 2013 Boston Superior Officers case, where the union had bargained in language that says you don't get transferred, we won't transfer you unless you will agree to it. And this court said, no way. No way, you don't do that, because that's a non-delegable management right of management. And how do you get those non-delegable rights? From the statute. 32B says that the appropriate public authority is the one that defines for plan design. Plan design, not contribution rate. All of the case law on plan design says 32B was put into existence for the specific purpose of volume purchase, and not only volume purpose, but getting the best deal for the employees. And it belongs to the appropriate public authority. Why? Because it's an executive function. The Anderson case that the arbitrator cited, okay, was not a case about plan design. It was not a case about co-pays and deductibles. The Anderson case that the arbitrator cited, and that has been cited, was about premium share, premium contribution, and it referred to two previous Medford cases that are about premium share, not plan design, not co-pays and deductibles. Because if you ever tried to bargain in the public sector with different bargaining units and try to develop a plan design for all the different bargaining, it doesn't work that way. That was not what 32B was all about. 32B says volume purchase, the more you put in, the cheaper it's going to be. And by the way, you know, it's an executive function. It belongs to the mayor or it belongs to the town manager, because guess what? He's covered by it too, or she's covered by it too. So he or she has absolutely no reason to eviscerate or come up with a bad plan design, because it will cover him or her and their families as well.
So do you agree that that HMO Blue and Blue Cross Blue Choice are not indemnity?
HMOs are not indemnities, but they're both covered by 32B, and they both have the same language that says it belongs to the appropriate authority. It's up to the discretion of the appropriate authority to design.
But do you agree that the two plans that have been mentioned here, the HMO Blue and the Blue Choice, are HMO plans, not indemnity plans?
HMO is not an indemnity.
I'm not asking you that.
I agree.
That the two ones that are mentioned, HMO Blue, and is it Blue Choice? Is that the other one? Blue Choice. Those two specific plans, they are HMO plans, not indemnity plans. Is that correct?
Oh, I think one is an HMO. I think the other is an indemnity. I don't know. I can't swear to that. My knowledge, my information was that, like all communities, you have an indemnity and you have an HMO. And one was an indemnity and one was an HMO. But both sections, whether you look at Section 3 or whether you look at Section 15, say that in the final analysis, whether it's indemnity or HMO, you know, it belongs to the appropriate authority to determine. It's at the discretion of the appointing authority.
So your view is that the Superior Court was right, but for the wrong reason?
Not really for the wrong reason, because when they're talking uniform, when the judge, we made the same arguments there, and the last pieces of paper that this court got on this case was a request, if you will, to strike the conclusion of the appellant's brief, and I answered that as well. And it was because of terminology. Terminology. Uniformity is part of what 32B is all about. When all of your court cases talk about it, They not only talk about it as a local option statute, not listed in Section 7 of 150E, and a specific purpose, but also says that specific purpose is developing the best and most economical plan for the whole. So how could you, for example, if you will, go to successor bargaining with the fire on their, if you will, demographics, and with the teachers on their demographics, and the police on their demographics, because that's what a plan is based on, demographics, the population that's being served. And the broader the population, the better the price, and as a matter of fact, the better the plan that can be determined, as opposed to a plan on each set of demographic groups. It's not realistic, it's not common sense, it's not logical.
All right.
So, as far as the court's decision, in my opinion, was right.
Okay, thank you.